This is Building Tomorrow, the Society of Construction Law Australia podcast.
On the show, you'll hear real conversations about what matters most to the people behind the scenes who are shaping Australian construction.
From lawyers and contract administrators to engineers, commercial managers, consultants, and all the other experts forging the future of Australian infrastructure today. I'm Mawona Matanda.
I'm BJ Lamsal.
And I'm Jennifer Raphael. Today we're chatting with Dawna Wright. Dawna is a highly regarded forensic accountant and Senior Managing Director at FTI Consulting. She has over 25 years' experience in auditing and forensic accounting, having held significant positions in Big Four firms. Dawna has particular experience acting as an expert witness in litigation matters, including construction litigation. Today we're going to chat with Dawna about her role as an expert witness. We discuss some of the challenges she faces in giving expert evidence, common misconceptions about her role, and practical tips for how lawyers can best brief forensic accountants. We will also discuss an important accounting standard that in-house finance and legal teams should be aware of, and how the standard can present particular challenges for construction companies. Dawna, welcome to the show.
Thank you. Thank you for having me.
It's wonderful to have you here this morning. So you're a chartered accountant and you specialise in forensic accounting. I thought we might start by exploring what that is and how that might differ from the accountant that people are used to going to in, business as usual or when they go get their tax done.
Yes, I'll say probably just like there's many different types of lawyers or engineers, there's many different types of accountants. I actually started my career as an auditor and I did that for about 8 or 9 years and then I went into forensic accounting after that. So the difference going into forensic accounting is a lot more specific problem solving. Most of your listeners probably know forensic means, relating to a legal or regulatory issue. That's what the word actually means. So most of our forensic accountants' work is dealing with some kind of dispute or investigation or regulatory inquiry or issue. So we're taking our kind of general accounting knowledge, but applying it to very specific problems and issues, which often intersect with the legal community in some way or a regulator in some way.
And what made you decide to go down that path? Like, what is it that attracted you about the forensic accounting world?
Yeah, that's a good question. Even way back when I was starting my university career, I was interested in the law. So I was sort of trying to decide between commerce and law. This is very long time ago. In those days, people didn't do double degrees. Now they do. So that's probably what I would have done now. But as soon as I heard about forensic accounting and how it kind of intersects with the law and helping lawyers, so my main day job is helping lawyers with their jobs, it really had an appeal to me from that sense early on. And then I suppose it was also there's some parts of the audit that I liked. I liked when it was a new audit and you had to figure out how to do the testing and that real problem solving side of it. That was always the part I liked about audit. So forensic accounting was a great way to combine the good accounting grounding you get from being an auditor, but then always doing something different every single day. And, every day is problem solving, solving a puzzle. So it was probably, that's what led me into it. And then, I've just enjoyed it. Every day has been different. So here I am still.
That's great. And so part of your work is also acting as an expert witness in litigation, in all sorts of kinds of disputes before the courts, but specifically also construction disputes. So can you tell us about the types of construction disputes where people might engage you to act as an expert witness?
Yes, you're right. So I deal in all sectors. So I don't deal specifically or only in construction, but as we know, there are a lot of disputes in construction. So I do a fair bit in that sector. They can range from early on kind of more tribunals and arbitrations through to litigation. So some examples would be where there's complex variation claims and they get into a more contentious situation. Sometimes a forensic accountant is needed to kind of unpick what's been paid and not paid. That might sound like an easy thing, but it's not always, as I'm sure many listening would know. So sometimes we're actually needed just to figure that stuff out. Sometimes it's where there's been a breach of contract or an allegation of a breach of contract, and it turns into a loss and damage scenario, which might be, if I'd not entered into this contract, what would the outcome have been? Or if it had been properly fulfilled, what would the financial outcome have been? Sometimes it's construction companies involved in just regular, litigation like class actions or, other just kind of general breach of contract stuff. So it can really range through all, I guess, the stages of a construction project, really.
Yeah, so lots of different variety there as to why a lawyer might need to engage you to act as an expert witness. What are some of the misconceptions that might be out there about your role as a forensic accountant, specifically as an expert witness?
Well, one is there's quite a few types of experts you might see in a construction dispute. And as an expert witness, we have to be super careful and upfront about what our expertise is and what it isn't. And in construction is one area where sometimes as an accountant, I get asked about, what the project should have cost in another scenario, or to quantify delays or the impact of delays. And that's where I would say there is a real distinction between, there's actually three types of expertise there. Forensic accounting, which is mine, which is about, I can talk about the costs that have been incurred. If we're talking about, delay scenarios, I can talk about what has been incurred, whether it's been paid, whether it's been accounted for correctly from an accounting sense. But when it gets to what should something have cost from a construction perspective, that's more a quantity surveyor or a QS. And then, in terms of reasons for delays and critical paths and things like that, that's a delay expert. So there's actually three different types of experts. And I think sometimes people might come to a forensic accountant just asking all of those questions. And so we have to often say, actually, you have to speak to my colleague about that part. I can answer this part, but not that part. So that's one of the common, I think, misconceptions, is that maybe forensic accountants can do maybe a little more than we can in some of those real deep construction industry disputes.
Right. And so on those types of matters that involve all of those different elements, what's really needed is your expertise as a forensic accountant, and then the expertise of, say, a delay analysis expert to give expertise about the delay aspect, and then potentially also a quantity surveyor to give their expert opinions about what it should have cost.
Exactly. Yeah. So it requires, I guess, a real collaboration, or, you kind of have to parse it all out into different parts and then bring it all together at the end, where each one expert's opinion might be the input to another's. So, for example, as a forensic accountant, I might be relying on the opinion of a quantum expert and a delay expert to feed into my analysis to quantify loss and damage, so economic loss and damage. So I would be taking their opinions and turning it into a cash flow analysis for the purpose of loss and damage. So you kind of have to parse it out in the specific questions, but then be able to bring it back together for an overall, opinion, or for the overall case theory, for example, in terms of legal submissions.
Right. And does that present some challenges for you in the way that you give your expert evidence then, when you're relying upon other experts, you're relying upon collaboration with those experts? What kind of challenges do you face when dealing with that?
Yeah, that's a good question, because it can actually be approached in a few different ways. So sometimes the one way would be the legal team wants to keep all of those opinions very separate, because they want them to each stand on their own, and they want to make sure that if one, falls over for whatever reason, it doesn't kind of infect the others. So sometimes it's actually not collaboration on the part of the experts. It's actually the legal team doing the coordination, but I need to be very clear with them on what I would need as an input. So I'd have to say, can you please get your, quantum expert to make sure the output comes in this way, because that's what I need to rely on as an input to my own. So sometimes I have to anticipate, what I need, but get the clear on telling the lawyers what I can do and what I need from them. And then it's up to them to communicate that to the other experts. Or the other way, sometimes we're actually doing more collaboration and coordination ourselves. So for example, where I have a colleague who's a QS, so he can do that side of it, we do one report where we're collaborating, but we might do the report in 2 sections so it's clear whose evidence is whose, but we're doing a little more collaboration internally as to how we're going to do that, how we're going to, one of us is going to impact the other. So it can be done in either of those ways.
And it's not just experts on the same side, is it? You're also dealing with experts from the opposing party. What kind of challenges do you face in that scenario?
Yes, sometimes we can have multiple experts and, it could be even multiple on each side. So then when we get all together in a conclave, or what's commonly referred to as the hot tub, it can actually get quite complicated. So we do have to figure out how to work effectively with people who are on the other side. I always approach it as our duty is to the court or tribunal or whatever process we're in. So, we should approach it with that goal in mind and be as collaborative as we can, at least in terms of being professional and being cordial, and, where there's something that needs to be conceded because we've, not been given some information or something like that, we need to be prepared to do that. But at the same time, definitely hold our ground and be able to defend our opinion in a conversation with someone else who's, generally trying to pick it apart. But if we've done, all our work up front, there shouldn't be any problem in defending that opinion. So the collaboration there is more about the process, trying to make the process go as smooth as possible so that we get to the outcome as efficiently as possible. And that outcome being, just a document that sets out our differences in a way that a tribunal or a court can just easily see what those differences are. So I guess my approach is always, we can do that in a collaborative way. It doesn't mean we're giving anything away in our opinions. It just means we're trying to do it in a professional manner.
Respectfully,
exactly, because that makes everybody's job easier. But also, like say, making sure we both have a goal of just producing something that a court or tribunal can easily understand. We don't have to agree with each other. We just have to be clear on where we disagree and why.
And this is all set out in sort of your joint expert report after this process that you go through with the conclave or the hot tub.
Yes, exactly. So in a perfect world, that process narrows the issue is in dispute, or at least, goes from what if each expert has a 100-page report, it can be distilled down to the main points, in a much more summarized format for the respective instructing solicitors, but also obviously for the court or tribunal to get their heads around easily.
And do you have any interesting war stories that you could possibly share about your time acting as a expert witness? Obviously, not disclosing names as such. Is there any interesting stories that you can share with us?
Yeah, I think there can be a bit of a moment of the penny dropping where we realize we don't have to agree. We just have to, agree to disagree, but be able to articulate why. But yeah, we've had some interesting cases, I think, especially in arbitration, where the tribunals have a little more leeway in introducing different processes. They're not as, stuck to the traditional process of joint report, cross-examination, etc. So I've had one case where the tribunal ordered a joint audit to be done. So rather than each expert going away and spending, a lot of time and money doing our own report and then going through a long joint process, the tribunals went to a joint audit. It still took quite a long time, but it was a very different way of doing it. It has its pros and cons because, trying to get 2 opposing experts to kind of collaborate all the way along over, I think it took about 2 years, was quite an experience. But yeah, I guess it's another way to do it. We've also had, sometimes the tribunals have, I think they now trying to get that joint process started a lot earlier. And we've had, examples where they want us to do like a joint report before we've done our own reports. So that makes it quite difficult because they're kind of expecting us to just be able to discuss and agree something without having gone through the thought process of, writing a report. So the writing of the report is a lot of the thought process happens as you sit down to write something, as I'm sure lots of lawyers would, have the similar view. Until you sit down to write it specifically, it's very difficult to get to a fully reasoned opinion. So I've found it quite challenging when the tribunal orders us to do a joint report before we've actually put pen to paper at all. So it just means you end up with some kind of odd outcomes where we're just both saying we don't really know what we're going to say, so we can't really help you much, tribunal. So please give us a different instruction or a different question.
Fair enough. Now, if we can turn to a topic that might be relevant to in-house finance and legal teams in construction companies, and that's revenue recognition. Not exactly a sexy topic for our listeners, but specifically I wanted to ask you about the AASB 15. Can you explain what this is?
Yeah, it might not be a sexy topic for your listeners, but I'm sure accountants would, find it very exciting. Yes, no, it's a good question. AASB 15, it's actually been around for quite a few years, but at the time when it was introduced, probably like, I'm going to say 6 years ago-ish, when it was introduced, it was a big change at the time. And it's probably one that, even though it was, like I said, quite a few years ago now, it's just still not been properly implemented. And it's one that, the regulators haven't really focused on. And as accountants, we see a lot of companies doing it incorrectly. The relevance to construction is that AASB makes revenue much more dependent on a contract and it applies to every industry. So it doesn't only apply to construction, and it wasn't written for construction, but it was written to focus the attention more on when has revenue actually been earned. And the kind of language used in the standard is that you have to pay attention to the performance obligations. And even saying those words, they sound a lot more legal than accounting related. So it has, in my view, made revenue recognition a lot more of a legal approach to comply with the standard. And as listeners would know, construction contracts are not straightforward at all. And I'm going to say, as a lay person, not a lawyer, identifying performance obligations and when they've been fulfilled when you apply that to construction and construction contracts, to me seems like a whole different, kettle of fish than your normal supply contract. And this same standard applies to supply of anything, but obviously construction is a whole world unto itself. So in my non-lawyer view, it seems a lot more complicated. So it means that I'll say the revenue recognition in construction, it has to go hand in hand with a legal analysis. So to your listeners who are in-house lawyers, I would say if they're not involved in their finance team's accounting policies, they should be. If they haven't already, they should go back and look at them. They should look at their contracts to see if the way they think, to check their implication on revenue recognition and vice versa. So it really has to be a hand-in-hand approach between legal and finance to me. And so I'll say if any of your listeners aren't kind of in that kind of close communication and relationship with their finance team, they should start that soon.
So is this relevant to all construction companies then?
Yeah, well, anyone who has to comply with the accounting standards. So yes, any, reasonable sized company that files financial statements. Yes. And certainly if they're publicly listed, but even, obviously it goes a lot broader than that as well.
So your advice to these in-house legal teams is to definitely look to understand more about what this is, engage with the finance teams, don't operate in silos.
Yes, exactly. Sit down with the finance team, ask them what the revenue recognition policy is, but also, pull out a contract and go through that together and make sure that the way you're wording your contracts in terms of performance obligations matches up with the accounting policy and vice versa. That make sure your finance team's accounting policies take into account the kind of contracts that you write or agree to with your counterparts as well, depending on which side, whether you're talking about it from the revenue side or the, supplier side.
And what are the implications then if people are getting this wrong?
Well, I guess at the lower end of the spectrum, their accounts will be wrong. But at the other end of the scale, especially if they're reporting to ASIC, it's an area that ASIC has said they're looking into more, and as they should, because the policy's been around for quite a few years now. So we should really see companies having it fully implemented by now. So ASIC has said, it's an area that they're looking at. So if you're an entity that reports to ASIC, you could have a compliance issue if they choose your company to look into, and there's issues there. But again, at the other one step further, to the extent revenue is incorrect, you could have continuous disclosure breaches if you're a publicly listed reporting entity with continuous disclosure obligations. So obviously the revenue that's disclosed is generally a material disclosure. So to the extent any revenue is being recognized incorrectly, you could also have a continuous disclosure breach, and or so what happens when those get corrected is potential shareholder class action if there's a material correction.
And this is something that you're finding is regularly not being done in accordance with the standard throughout the industry.
Not only this industry, I'll just say generally. I don't want to say it's not only in construction, it's just construction is obviously a lot more complex, so it's harder to get right and easier to get wrong. And as we know, because of things like variations in contracts, the revenue isn't clear at any point in time. So that's what makes it harder in this industry than many others. But I don't want to say it's only being done poorly in this industry. I don't want to single out this one. I'll say it's probably just more generally it's not being done well.
Well, if we can change tracks then and come back to talking about your role as a forensic accountant, what should lawyers be doing when they're considering briefing you as a forensic accountant? How do we make your job, your life easier?
That's a good question. Well, I think that goes both ways. So we're here to try to make, the lawyers' lives easier and hopefully vice versa. But I'll say generally it's the first way around. But I think obviously thinking about it sooner rather than later, because what makes it difficult for everyone is, and I'm sure lawyers have to say this to their clients as well, kind of getting the calls at the last minute make it harder because you can't, give a very good advice or opinion. But so I'll say sooner rather than later. But then I would say consulting on what questions should be asked. And I know it's a bit of a delicate area because we have to maintain our independence. So getting involved in, the question that should be asked can sometimes cross the line into being more biased than independent. But I'll say there's always a level of consultation that's appropriate because, lawyers need to know that they're asking a question in a way that makes sense, that in a way that can be answered, is capable of being answered, and in a way that obviously fits the evidence that they're trying to obtain. So that part they will know. But the second part about is a question capable of being answered, they kind of need to ask the accountant, in advance. So I think it's always appropriate for there to be at least some level of consultation on questions that can be done very appropriately without any breach of independence. And that just makes the rest of the process a lot easier, because if a question is asked in the wrong way or in a way that the lawyer might think they're asking one thing, but it means something else to an accountant, a lot of time and effort can be wasted in trying to then correct that, or either figure out what's meant or correct it if needed down the track. So it's always more efficient and effective, I think, to check the question first.
Absolutely. Yeah, that engagement on the question really goes to impact the quality of the answers that you can give. So it definitely makes sense to have more of that consultation at that early stage, as you said. So we've spoken a lot about your role in the context of sort of litigation or arbitration of those more formal processes, but do forensic accountants have a role to play in helping parties avoid litigation and dispute altogether?
Yeah, that's a good question. I'll say certainly in combination with, say, the QS, quantity surveyor side of things, definitely. And what I mean by that is I think construction disputes often arise through the variations process or, as a result of not being able to resolve those effectively. And so the more the company can do upfront to manage that process, I think that goes a long way to being able to avoid more formal disputes down the track. So to do that, you kind of need the kind of more QS skill set. But the role of the forensic accountant there is either in kind of just helping or avoid the situation where the claims and what's paid and not paid and what's been processed and matching things up gets so messy that it can't be resolved commercially because the records aren't there or they're not being kept in a good way. Neither side really has the full picture of what happened and why and when. So I'll say one of the, to me, a way to use the skills to avoid disputes down the track is kind of having that upfront assistance in managing claims between forensic accounting and QS. It's probably not, I don't know if forensic accounting can do it on its own, but I'd say the combination of the two would be very useful in avoiding disputes.
And what about the role of AI? Are you seeing that much in your industry? Are you utilizing it in your work?
Yeah, that's a good question. We're starting to use it more and more, but more for analyzing information that we have as opposed to writing. We can't use, I should say straight off the bat, we can't use AI to write a report, and we don't want to use AI to write a report, and there's practice notes that go to that. So we're not using it to write expert reports. But what it can be very useful for is helping us distill large volumes of documents and information, which obviously in construction disputes there are. And a lot of the, even if it's not a large number of documents, the documents that are there are very long and complex. So for us, being able to differentiate or identify key differences in, for example, a few different versions of a document, or get a good high-level understanding of what kind of documents we have, and then helping us to choose the ones we need to review more specifically or do kind of that high-level comparison or a high-level timeline, things like that. So we're kind of using it as a tool to help us deal with extremely large and complex data sets.
So it's not replacing your role as the expert in terms of the opinions that you give. It's really just helping you to do that task better by taking care of what sounds like more of the administrative side of things as opposed to the fundamentals of your role as an expert.
Exactly. Yeah, it's not replacing us yet anyway. I don't know about down the track, but so far it's not replacing us yet. But it's helping kind of supplement, I'll say, the similar tasks that our graduates and first-year consultants might do. So it's helping them be more efficient at their job, and so that they can then, move on to the more analytical stage more quickly.
Thanks very much, Dawna, for your time here today. If there's one takeaway that you'd like our listeners to take from today's discussion, what would that be?
I guess if there's a leave behind or a takeaway, it's, really the intersection between accounting and the law in construction it's almost fundamental, at least from the accounting side. The legal side is fundamental to that. So yes, again, for the, lawyers, especially the in-house lawyers, but even the external advisors as well, just, make sure that they're, in dialogue with the accounting and finance and other, valuations, other people that they come across, because, it's a real intersection. You almost can't have a good understanding of the financial aspects of construction accounting without any understanding of the legal. So please help out your accountant and finance people.
Thanks for listening to Building Tomorrow, the Society of Construction Law Australia podcast.
The Society of Construction Law Australia is a national organisation of members at all stages of their professional career with a shared interest in construction law.
For more info about the Society of Construction Law Australia, head to their website, scl.org.au. This show was produced with strategy and production support from Sound Cartel.
To make sure you don't miss an episode of Building Tomorrow, be sure to subscribe to or follow the show in your podcast app.
And while you're there, leave us a 5-star review. It really helps others find the show. I'm Mawuna Matanda.
I'm Vijay Lamsal.
And I'm Jennifer Raphael. and we'll see you in the next episode of Building Tomorrow.